Open it, Andrew. A woman with nothing to hide doesn't flinch at paper. My mother-in-law said that standing at the head of a table of 40 people, in a parish hall that still smelled like candle smoke, 11 minutes after a priest had poured water over my son's head. She was holding a courier envelope up beside her face, the way a game show host holds a card. My husband was still wearing the ribbon they pin on the father. Our son was 7 weeks old, and asleep on my shoulder in a gown that had been in her cedar chest for 31 years. It's a paternity test, she said to the room, not to him. I ordered it in January. I paid for it myself. Somebody's fork stopped halfway to their mouth and stayed there. That is the part I remember most clearly. Not the gasp. There wasn't one. The silence, and one fork in the air, and Father Brennan setting his glass down without any sound at all. The way you set something down when you don't want to be the person who moves next. Glenda Whitcomb has a church voice. She used it. Everyone here loves this baby, she said. So everyone here deserves to know whose he is. My son married a court stenographer from 3 counties over. A girl who types up other people's lives for $11 a page and doesn't have a single relative within 100 miles of this room. Then a baby arrives 8 weeks early and we're all just supposed to clap. 3 things in under a minute. My marriage was a lapse in judgment. My work was a thing to be priced. My son was a question. Drew said, "Mom," 1 syllable, no weight behind it. She put the envelope in his hand and closed his fingers around it. Open it. If I'm wrong, I'll apologize in front of every person in this room and you'll never hear it again. And then she did the thing that made a woman at the far end of the table stand halfway up out of her chair and then sit back down, because there was nowhere to go. She reached into her purse and set a pacifier on the tablecloth. Pale green, with a little chip in the ring where it had gone under the crib rail. I had turned the house over looking for it 3 weeks earlier and had cried about it once, in the shower, because I was 7 weeks postpartum, and it was the only thing I could think of to cry about. I already had his, she said. I took it in February. It only needs the spit. That is when the room understood that this was not a threat she had made in a moment. It was a thing she had been carrying, sealed, through the mass, through the water, through the part where she held him at the font and said the words a godparent's mother says, with a lab's results already sitting in her purse under her reading glasses. I did not scream. I want to be honest about why, because people always want to know why. It wasn't dignity and it wasn't shock. Owen was asleep against my collarbone with his fist inside my necklace, and I was not going to let the first loud thing in his life be his mother. So I did the only thing I know how to do. I made a record. While every face in that hall was pointed at my husband's hands, I bent down and picked up the outer courier sleeve she had dropped on the chair beside her, and I photographed it. The barcode, the lab's name in Cleveland, the account line, and the case number printed under the words, "Client Reference." Then I walked to the back of the room, past the sheet cake with his name on it in blue gel, and I asked the photographer we'd hired for the day, a woman named Kayla, who was standing very still with her camera at her hip because nobody had told her whether to keep shooting, and whose camera had been rolling the entire time because the family had paid for a highlight reel of the toasts, and she had started the clip before Glenda stood up and had never once thought to stop it. If she would sell me the original card, not the edited gallery, the card, everything from the last 12 minutes, untouched, before she put it in a computer. She said, "Are you okay?" I said, "I'll pay you now." My thumb was pressed into the seam of Owen's gown, hard enough that the embroidered initials left a mark in the pad of it. NF, in ivory thread. Glenda had told me at the fitting that they stood for Nana Florence. Behind me, my husband was reading. He read it once fast, the way you read a number. Then he read it again, and his mouth went strange, and he lifted his head and looked at his mother in a way I had never seen a grown man look at his mother. "Mom," he said, "why does the second page say you and I aren't a match either?" She crossed the floor faster than a 64-year-old woman should be able to. She took the pages out of his hands, both of them, and she went out through the kitchen door past the coffee urns, and the screen door hit the frame twice, and 40 people sat in a room with a cake and a baby and no explanation. She thought she had handed my husband a piece of paper. She had handed me a case number. 6.5 months later, a judge 3 hours north of that parish hall would read that number out loud in an open courtroom, and then she would read the name on the account that had paid for the test, And it was not Glenda Whitcomb's name. That is the whole story. The rest is just how long it took me to get it entered. I'm Paige. I'm 29. I sit in rooms and write down exactly what people say, which is a strange job to have and a stranger one to be married into. If you're the kind of person who wants to see the receipt before you believe anybody, stay with me, because there's a receipt, and it comes with a check image. Tap the subscribe button so this doesn't vanish out of your feed halfway through, and tell me in the comments what you would have done when that pacifier hit the tablecloth. I need to know I'm not the only one who went quiet. Here's the first thing that happened, because it happened faster than she expected. That lab in Cleveland has a compliance line. On Tuesday I called it, and I did not shout, and I did not accuse anyone of anything. I said, I'm the mother of the minor whose sample you tested on case number 31902, a pacifier taken out of my house. I did not consent to the collection, and I'd like the complete file. Under their own policy, a parent of a minor participant is entitled to it. They asked me to send proof of the child's identity and my own. I sent it at 9:40 that morning. By Thursday, two things were true. The report Glenda had waved over a sheet cake had been withdrawn as non-compliant and marked unauthorized minor sample, which means that in any court in this country, it is now worth precisely nothing. And her client account with them was closed, permanently, with a letter mailed to the address she'd used. She had spent $490 to prove I was a liar, and 4 days later the only thing that piece of paper could legally prove was that she had taken a sample off a baby who wasn't hers to swab. That was the deposit. I want you to hold on to the size of it, because it was small, and because I already knew from the first phone call that there was something much bigger sitting underneath. The file the lab sent me was 17 pages, and page 9 was a scanned image of the check. I'll get to the check. First, you need to know why a woman spends 31 years being pleasant to everyone in a parish and saves the ugliest thing she has ever done for a stenographer from 3 counties away. Glenda decided about me in the first 4 minutes. Drew brought me to her kitchen in the spring, and she asked what I did, and I said I was a certified court reporter, freelance, mostly depositions. She was rinsing a colander. She said, "So you write down what people say?" And I said, "More or less." And she said, "Word for word?" And I said, "Word for word, that's the job." She turned the water off. She dried her hands twice on the same towel. For 2 years after that, she was warm in the way people are warm in front of witnesses. She sent Drew home from Sunday dinners with containers and sent me articles about how stress affects fertility. When we got engaged, she cried and told the parish office we'd be married in the fall before we had a date. Then, twice, she got quiet and got busy at the same time. Once when Drew mentioned that I could pull public records for people as a favor, and once at Thanksgiving, when his sister Margot joked that I should look up what the old Whitcomb place had sold for in 1988. I laughed, and Glenda said, without turning around from the stove, "We don't dig up family." I thought it was pride, old money habits in a family that didn't actually have old money. I was wrong by about $600,000. We got home from the parish hall at 4 in the afternoon. Drew carried the car seat in and set it on the kitchen table and stood with both hands on the back of a chair, and he said, "There's an explanation." I said, "Probably. She's 64. Those tests get switched all the time. You hear about it." "You do hear about it," I said, and I went upstairs and fed our son, and when he was down I sat on the floor of the nursery with my back against the crib and wrote that lunch out in shorthand, dated and timed and initialed at the bottom, because that is what you do with a contemporaneous record. The lab's own file did not come until 5 days later, on the Friday, at 6:12 in the evening, 17 pages, released to me because I had asked for them as the mother of the child whose sample they had run. Pages 1 through 7 were what you'd expect. Owen and Drew, probability of paternity, 99.999. My husband is my son's father, which I have never once wondered about, and which is now a sentence in a PDF I will have forever. Page 8 also had the second comparison, the one she had ordered without telling anyone. She could not get a sample from Drew without asking him for it, so she had used his razor, and a razor fails about a third of the time. So she had paid the extra $90 for a grandparentage panel as a backup and sealed her own cheek swab into the same envelope. And when you submit 3 samples, a laboratory reports on all the pairs. That is the entire reason I have a story to tell you. She bought a spare. Alleged grandmother to alleged grandchild. Excluded. Alleged mother to alleged son. Excluded. 0 shared markers where there should have been half. Page 9 was the invoice. Payment received, check number 411, drawn on an account at Fidelity Reserve Bank, and above the routing line, in the raised print of a real checkbook, 3 words I had never seen before in my life. Ferris Family Trust. And under it, on the signature line, G. Whitcomb, trustee. I sat on that nursery floor for a long time with the phone screen going dark and lighting up again every time I moved my thumb. Somewhere below me, my husband was on the phone with his mother, and his voice was doing the thing men's voices do when they're being talked out of something, going up at the ends. I did not go downstairs and tell him. I want to be clear about that, because later people acted like I had been sneaking around my own marriage. What I had at that moment was a woman who had ambushed a christening, a report that excluded her from her own son, and a check from a trust with a stranger's name on it. If I brought that downstairs that night, it would go straight to Glenda inside an hour, and whatever a Ferris family trust was, it would be a different shape by morning. So I did what I do in a deposition when a witness says something that changes the case. I didn't react, I wrote it down. Then I got up and made a list of what I already had a legal right to look at, which turned out to be almost everything that mattered. The next morning she called the house 11 times. By afternoon she had a story, and it was a good one, which frightened me more than the bad ones would have. There had been a mix-up at the collection site. She had been misled by an online company. She had done it out of love. She had done it because a mother protects. She had done it because she had heard something at the parish that she would not repeat in front of her grandson. And now she was the one being punished. That last part was the tell. She was not defending the test. She was already 3 moves past it, building the room she wanted us all to stand in. Rowena Pike called me on Wednesday. Rowena is Glenda's first cousin, 68, an attorney with an office over the flower shop on Delancey Street, and she has done every deed, will, and estate in that family since before Drew was born. She has a voice like a hand on your arm. Paige, honey, what a mess. Glenda's sick about it. Is she? She's not a young woman. If this gets talked about, if it gets formalized in any way, it's her health we're gambling with. I've drafted something simple. A letter, family to family. She apologizes in writing, you accept, everybody puts it away. Send it, I said. You'll sign it? Send it, I said. And I'll read it. Which is a different sentence. And she didn't hear the difference, and I made a note of that too. Here's a thing about my job. In 1,100 depositions, I have watched attorneys lose cases because they wanted the other side to admit something. They never admit it. What ends people is documents they filed themselves, on days when they felt safe. So I stopped listening to what the Whitcombs said, and started collecting what they had signed. The name Ferris took me 4 days. Drew had never heard it. That was the first real crack in the floor, and it happened at our own kitchen table on a Sunday morning, with the church bells going 3 blocks over. I said it flat, no lead-in. Ferris, does that mean anything? A family, a business, anything? And he chewed and thought about it and said no. Then he said, wait. And he said his father used to get mail once a year, February, a window envelope he'd take out to the truck to open. Drew was maybe 10. He asked about it once and Ellis said it was insurance. Ellis Whitcomb died in 2019. He was a decent man who let his wife handle everything, which in my experience is a kind of decision people don't like to call a decision. Here's what took the other 3 days. In Pennsylvania, a will is a public document. Once it's probated, it sits in the Register of Wills, and any human being who walks in off the street can ask for it. You don't need a lawyer. You don't need a reason. You need $8 in the right county, and the right county is not the county you live in. Vance County is 190 miles north. I drove up on a Thursday with Owen in the back and a cooler of bottles, and I fed him in the courthouse parking lot with the door open and my feet on the asphalt, and then I carried him in on my hip past a metal detector and a man who told me the elevator was slow. The clerk found it in about 9 minutes. Harlan James Ferris. Died March 2001, Vance County. Machine shop on Route 6, sold 2 years before he died. A will, 11 pages, and a trust inside it. I read it standing up at the counter, because there is a thing that happens in your legs when you find it and you cannot make yourself sit down. He left everything he had, $318,000 in change, in 2001, in trust for the benefit of the son of my late daughter, Nell Ferris, born September 12, 1994, whose whereabouts and rearing are known to my executrix. Known to my executrix. 2 pages later, the distribution clause. Income for the beneficiary's health, education, and maintenance during his minority, and an account to be filed with the court every February for as long as that minority lasted. Principal to be distributed outright to the beneficiary at age 35, or, and I read this line 4 times with my son's head under my chin, upon the birth of the beneficiary's first child, whichever shall first occur, at which time the trustee shall render a full and final accounting to this court, and should the beneficiary not survive to distribution, then to his issue per stirps. Owen was born on the 18th of January. The christening was the 8th of March. She had not ordered that test because she suspected me of anything. She had ordered it because my son's existence had started a clock on her, and the fastest way to stop a clock is to prove the child doesn't belong to the man it's ticking for. Drew turns 35 in 2029. The clock had always been coming for her. My son had simply moved it up 3 years. That is what a baby cost her. 3 years to sell a cottage, refill an account, and hand a clean number to a judge. She was never trying to win. She was trying to make the audit late. I asked the clerk if the trust file was separate. She said, "Yes, honey, that's Orphans Court, 2nd floor, and the accountings are in there." And I said, "How many?" And she went and looked and came back and said, "It's a box." Down in the parking lot, I strapped him in and stood there with the door open and my hand on the roof of the car for a while. Then I called Drew and said, in a completely normal voice, that I had taken the baby to see a friend and we'd be back by 7, which was true in every word and false in the whole sentence, and I am not going to pretend to you that it wasn't, because that was the day I stopped being somebody this was happening to. The orphans' court file room on the 2nd floor is a long counter and a wall of gray boxes and a woman named Peg, who has worked there since the Clinton administration, and who took one look at the baby and got me a chair. 25 accountings, one for every year since 2002, filed each February, which is when a man in a truck used to open a window envelope and tell his 10-year-old it was insurance. They are boring documents. That is their entire genius. 2 columns, a cover page, a signature. I read them in order, and I did the thing I do at work where my hands go ahead of my brain, and by the 4th one I had noticed the sentence, because it is the same sentence 25 times, with the year changed. The beneficiary remains a minor in the care and custody of the trustee. No distribution is appropriate at this time. She wrote that in 2013 when Drew was 18 and had a lease. She wrote it in 2016 when he was 21 and selling commercial policies out of the family agency on Delancey Street. She wrote it in 2022, 4 months after she stood in a church and watched him marry me. Under the disbursements, there were trustee commissions every year, modest enough to look reasonable and consistent enough to add up. There were payments out for beneficiary maintenance to a household he did not live in. In 2008 and again in 2021, there were 2 large transfers, $94,000 and $112,000, both to Whitcomb and Doyle Agency, which is the insurance office my sister-in-law Margot runs and where my husband has a desk. In 2023, there was a line for $26,000 to an education savings account for a beneficiary listed only by initials, EMD. Etta Marie Doyle is 9 years old, has a gap in her front teeth, and once spent an entire Thanksgiving showing me how she can name every bone in the hand. And on the last page of the most recent filing, the balance the court had been told the trust was holding, $206,000. Every page was prepared and countersigned at the bottom by counsel, Rowena L. Pike, Esquire, Delancey Street. Peg said the certified copies would run me $1 a page, plus the certification, and would take about 7 weeks because the girl who does them is only in on Tuesdays, and there was a backlog on certifications. I said that was fine. I filled out the request form for all 25, and the will, and the 1996 adoption petition that started the file, and I paid $482 out of the account I keep for my own quarterly taxes. And I drove home, and I made dinner, and my husband asked me how my friend was. I said she was going through something. 7 weeks. That was the number I had. 7 weeks before a box of certified paper landed on my porch, and until then, everything I knew was just a story I could tell, which is the same as nothing. Drew requested his original birth certificate on the Tuesday after the christening, before any of the rest of this had started. I want to be fair to him here, because I've been unfair to him in my head about 11,000 times since. In Pennsylvania, an adopted person over 18 can ask the state for a non-certified copy of the certificate that was issued when he was born, before it was sealed. It costs $20. It takes about 4 weeks. He didn't want to do it. He filled out the form at our kitchen table with the pen digging into the paper and said 3 separate times that this was going to kill her. It came back on the 9th of April. Mother, Nell Adele Ferris, age 22 of Vance County. Father, Ellis Whitcomb. He read it in the driveway with the mail still under his arm, and I watched from the window, and he didn't come in for 20 minutes. That night he found her obituary on a newspaper site in about 90 seconds. 4 inches of type from January of 1995. Nell Ferris, 22, of Vance County, died Sunday as a result of injuries from a motor vehicle accident on Route 6. Survived by her father, Harlan, nursing student. The paper had used her graduation photo from high school, and she looked like nobody. She looked like a girl at a bus stop, and my husband sat on the edge of our bed holding a laptop and said, "She was a person." I said, "Yes." He said, "She was a person and I'm 31 and I found out on the internet." That was the night I thought he was mine. Then on Saturday he drove to his mother's house and told her he had the birth certificate. He told me afterward, standing in the kitchen, defending it before I'd said a word. She was going to hear anyway. He wasn't going to let her find out from Rowena. She cried on him for an hour and told him she had held him at 4 months old in a hospital hallway and made a promise, and that the woman had been troubled, and that Ellis had begged her, and that she had never once in 31 years let him feel like anything but hers. "She's still my mother," he said. "Whatever that paper says, that's not a thing you can undo with a form." "No," I said, "but she took our son's pacifier out of this house and mailed his spit to Ohio. She's going to apologize. She had it in her purse during the mass." He put both hands on the counter. He said, "Can we please keep this in the family?" I said, "Sure." I have thought about that word a lot. It was the first move I made against my own husband, and I made it in a flat voice while wiping a bottle nipple with a dish towel, and it cost him 6 weeks he is never going to get back. 2 days later, I called the parish office to order a baptismal certificate. That's all. A piece of cardstock with a seal, $4. The kind of thing you tuck in a folder for kindergarten registration in 5 years. The secretary was quiet for a second too long and then said the entry hadn't been made yet. I asked what that meant. She said the register gets written up after, sometimes a few weeks, and father was aware, and that she was very careful, and I could hear her being careful. A member of the family had asked whether it might sit until the situation with the parentage was clarified, so that the book wouldn't have to be corrected later. The book. There is a bound register in a safe in that parish, with every baptism since 1901 written into it by hand, and my son's name was not in it, because his grandmother had made a phone call. I was 14 the last time somebody kept my name out of a book. It was a custody hearing in a county I don't live in anymore, and I told a judge what I had seen in my own house, and the judge said kindly that we'd note the child was present. Not what I said, that I was present. I went home and my life got decided by pages I wasn't on, and 8 years later I paid $2,300 to learn a machine that puts every single word somebody says into a record that cannot be edited, and I have never once in my career let a sentence go by unwritten. She could call me a liar in a parish hall. Fine. She had now reached into a book and taken my son out of it. I stood in my own hallway with the phone against my ear and the dial tone going, and I did not cry, and I did not call my husband, and I did not call her. I opened my laptop and typed one line into the notes file where I keep everything, and it is the only line in the whole file that isn't a date or a document number. She has 3 weeks left of thinking this is about the baby. Rowena's letter came in a cream envelope with her firm name embossed on the flap. It was 2 paragraphs. Glenda regretted that a private family health matter had been raised in a public setting. I regretted any distress caused by my reaction. Both parties agreed the matter was closed and would not be discussed with third parties, including but not limited to members of the parish, medical providers, or any legal or governmental body. That last clause is why I signed it. You have to understand what a lawyer is telling you when she writes that. Rowena Pike was not afraid of the parish. She had drafted a gag against a governmental body over a home DNA kit, which means somebody in that family had lain awake at night thinking about a filing cabinet, and it wasn't about a swab. I signed it on the 26th of April at their kitchen table with a pen Glenda handed me, and I said the sentence I had practiced in the car. I overreacted. I just had a baby and I wasn't sleeping. I'm sorry. I watched her face do something I will be able to see for the rest of my life. Relief first, and then, right behind it, before she could get her mouth in front of it, contempt. Because I had folded, and in her arithmetic folding meant she had been right about me all along. A girl who types, 3 counties from anybody who'd stand up for her, who cries in a shower over a pacifier. She took my hands, she said, "Now, doesn't that feel better?" Drew exhaled like a man setting down a couch. That night she called 11 people. By Sunday the parish version was settled. There had been a misunderstanding, the young mother had been under strain. Glenda had handled it with tremendous grace. Her 65th birthday was the 2nd of May, in the same hall, with the same folding tables. She asked if she could hold Owen for the photographs, and I said of course, and I stood 4 feet away with my hands empty, and let a woman who had mailed my son's spit to Ohio without asking hold him up next to a cake while 40 people applauded. That is what a signature buys you. It buys you a room full of people who think the thing is over. Somewhere in the middle of that party, Margot put her arm through mine and said warmly, "I'm glad you came around. Mom's been so worried about the agency this quarter, and she does not need the stress." I said, "The agency?" "Expansion," Margot said. "Second office, Mom's putting in 88,000 out loud, over sheet cake, into the ear of the one person in that room who had read 31 years of what that money actually was. I said, "That's generous of her." 9 days later, on the 11th of May, Rowena Pike filed the annual accounting for the Ferris Family Trust in Vance County Orphans Court. It had been sitting on her desk since February. They'd held it while things were unsettled. Now things were settled. Page 2, same sentence as always. The beneficiary remains a minor in the care and custody of the trustee. Signed that week, in the year my husband turned 32. They didn't file it because they were stupid. They filed it because I had apologized. I need you to sit inside those 9 days with me, because it is the only part of this I would live again. Every morning I got up and made coffee and put my son in the bouncer and answered a text from my mother-in-law with a heart on the end of it. Every afternoon I sat in a conference room and typed down other people's arguments about easements. And on my porch, on the 8th of May, wrapped in brown paper and taped by a woman named Peg, who had put a sticky note on top that said, "Sorry it took me an extra day," P, was a box weighing 11 pounds. 25 certified accountings, the will, the 1996 adoption petition. I did not open it in the house. I opened it in my car in the parking lot of the elementary school on Cortlandt Avenue, with the engine off, and I read for 2 hours while the crossing guard came and went, and then I called an attorney in Vance County named Adele Krantz, who does trust litigation and nothing else, and I told her I had a question about standing. She said, "Who's standing?" I said, "My son's." There was a pause on that phone line, and then a chair moved, and then she said, "Read me the distribution clause again," slowly. Adele Krantz is 55, wears reading glasses on a chain like a woman 40 years older, and explained my life to me in 9 minutes. A trust has beneficiaries. The beneficiaries are the only people who can make a trustee open her books. Drew was the beneficiary, and Drew, at that moment, was a man who wanted this kept in the family. But Harlan Ferris had written 2 clauses about a grandchild. The first made the birth of my son the event that ended the trust, triggered the final accounting, and put a duty on the trustee that she had spent 4 months trying to make disappear. The second was 11 words long and sat at the end of the sentence like a man clearing his throat. Should the beneficiary not survive to distribution, then to his issue. That gift over is your son's ticket, Adele said. It makes him a contingent remainder beneficiary of that trust. Without it, you are a spectator with a grievance. With it, he is a party in interest, and a party in interest can make a trustee open her books. He's 4 months old, so he can't file anything himself. His natural guardian can file it for him. That's me. That's you. She took the glasses off. I said, I signed something in April. I gave her the cream envelope. She read it in about 9 seconds and handed it back. You signed that in your own name, not as anybody's guardian, so it does not touch one right your son has. And a clause trying to gag you in front of a court or a licensing board isn't worth the postage. You cannot contract away somebody else's ability to look at a fraud, and there's no consideration in here anyway. She dropped it on the desk. She bought silence she was never able to sell. Mrs. O'Neill, I'll be direct. I have had this conversation maybe 6 times in 22 years, and usually the family wants to know if there's a way to do it quietly, and there is, and it's called a demand letter, and it works about 1/3 of the time. I said, I don't want a demand letter. Why not? Because she'll say she made a mistake and pay some of it back and be at the table at Christmas. Adele wrote something down, she said. Then we file a petition to compel an accounting and remove the trustee, and we do it in open court, and I need every original you have. I had a box. The other thing I had was 12 minutes of video that nobody had watched. By the middle of May, the parish story had hardened into something I couldn't have shifted with 100 conversations. A young mother, overtired, had made a scene at a christening lunch. Glenda had been so gracious about it. 3 women had already told me, kindly, that the first year is hard. I didn't argue with any of them. Arguing is for people without an exhibit. I put the raw card in an envelope with a 1-page letter to Father Brennan. I did not editorialize, and I did not ask him for anything. I wrote that this was the unedited file from the photographer we had hired, that it began 4 minutes before and ended 8 minutes after, that I understood the register entry for my son was being held pending clarification of his parentage, and that the attached lab report established his paternity at 99.999%, and that if he preferred, he could watch it with the deacon present. He called me on a Thursday morning. He is not a dramatic man. He said, Mrs. O'Neill, I've made the entry. It's dated the 8th of March, which is the date it happened. I've also asked Mrs. Whitcomb to step back from the festival committee this year. I said thank you. He said, I served that lunch. I stood 4 feet from you. A pause. I want you to know that I asked her, that afternoon, why she couldn't have waited a day. She told me it wouldn't have been as effective on a Tuesday. That was the first thing anyone ever took away from her. And it was a folding table committee that runs a raffle in August. And she went home from the parish office and cried on the phone to my husband for 40 minutes about being humiliated by strangers. Drew told me about it at dinner, watching me, testing which wife was at the table. I said, that's hard. 2 things about the 2 weeks after that. The first is that on the 14th of May, Adele Krantz filed a petition in Vance County Orphans Court on behalf of Owen James Whitcomb, a minor, by his natural guardian, seeking a full accounting of the Ferris Family Trust from its inception, the surcharge of the trustee, her removal, and the imposition of a constructive trust on any property bought with trust money. Filings get docketed immediately. Service takes as long as service takes. In that county, in May, it took 12 days. The second is what Glenda did with those 12 days, believing herself to be a woman who had won. On a Tuesday, I had a deposition in Harrisburg, a 2-day construction case, 10 hours of a man explaining soil, and my sitter Nora had Owen from 7 to 6. Glenda let herself in with the key Drew had given her when Owen was born, went upstairs to the dresser in our room, and took the christening gown out of the second drawer. Nora called me at the lunch break, upset, apologizing, because Glenda had also picked Owen up out of the playmat and told her she was taking him to the park at Weller Street, since his mother works, and Nora had had to physically stand in a doorway and say no to a 65-year-old woman for 11 minutes until she put him down. I sat in my car outside a law office in Harrisburg with a salad I didn't open. Then I sent one text. Please put the gown back on the porch by Friday and leave the key with it. She replied inside a minute, all warmth, that the gown was a Whitcomb heirloom and belonged in the cedar chest with the family things, that she'd had it cleaned, and that it wasn't healthy for me to be so possessive about objects. Then, 6 minutes later, a second one. I know what you did with that video. Father Brennan is a fool who is being manipulated by a girl who has been in this parish for 4 years. I read both twice, and then I forwarded them to Adele, and Adele wrote back 4 words. Don't answer, keep both. Every day of those 12 days, she did something that made the paperwork worse, and none of it felt like victory to me at the time, and I'm not going to pretend it did. It felt like being scraped. What kept me upright was a thing I have known since I was 14 years old, which is that a record does not care how anybody felt. The sheriff's deputy served her on the 26th of May, at 10:40 in the morning, at the counter of Whitcomb and Doyle Insurance on Delancey Street, in front of Margot, 2 producers, and a client renewing a garage policy. Margot called Drew before the deputy was out the door. Drew called me. I was in the car line at Nora's. He said, "There's a court thing, about some trust. Mom's saying it's from Owen." I said, "It is." Silence. He said, "You filed something in our son's name and didn't tell me." I said, "You told me to keep it in the family. He's family." Hung up on me. He came home at 11 that night and sat on the end of the bed in the dark with his shoes still on, and he said, "How much?" I said, "The court will decide." He said, "How much do you think?" And I said the number I had been carrying around for 18 days, the one I had added up 4 separate times on a legal pad in a school parking lot. And when I said it out loud in our bedroom, it did not sound like money. It sounded like the 25 years he spent thinking his family had nothing. 2 days later, Fidelity Reserve froze the trust account, because a bank that receives notice of a citation regarding a fiduciary account does exactly one thing, and it does it that afternoon. Which meant that the $88,000 my sister-in-law had already spent on a lease deposit, a build-out contract, and a signed offer on a second storefront in Kingsley was, as of 3:15 on a Wednesday, not coming. Rowena Pike withdrew as counsel for the trustee on the 2nd of June. I want to explain why that one line was the moment I knew. A lawyer who has prepared 25 annual filings for a client does not walk away from that client in week 2 because of a scheduling conflict. She walks away because she has read the petition and understood that every one of those 25 filings has her name at the bottom of it, and that from this point forward, her client's defense and her own are 2 different animals that are going to have to eat each other. Glenda called me 11 times that week. I let it go to voicemail 11 times, and I transcribed all 11 because that is a skill I have, and because Adele had asked me to. The last one was 51 seconds long. She said, "You know what you are? You're a stenographer. You've never had an original thought in your life. You just sit there and take down what better people say." I typed it up, dated it, and put it in the folder. She had told me, at the start, exactly what she was afraid of. It only took me 7 years to hear it. They asked for a meeting on the 8th of June, in Rowena's old conference room over the flower shop, which Rowena had graciously vacated for the occasion, and which is a detail that tells you everything about how that family understood what was happening to them. Adele told me I could go alone if I wanted to, since their side no longer had counsel and nothing said in that room could bind my son. She gave me one sentence I was allowed to use, "That's for the court," and told me to write down every word of the rest. Glenda came in a navy dress with her hair set. Margot came in a blazer with her phone face down on the table. Drew came because I told him he should, and sat between us, and that is where he sat for the entire summer, in the middle, being asked to be furniture. Glenda had a folder too. Hers had 1 page in it. $206,000, she said. "That's what's there. Andrew gets all of it, every dollar, and I'll sign whatever you want, and the case goes away. That's more than fair to a boy who never earned a cent of it." I said nothing. Margot said, "Paige, she's 65. Glenda said, "I raised him. I was up with him with croup. I sat outside an emergency room with him when he was 6. And this, a child not 5 months old, this is what you use? You put a baby's name on a lawsuit?" She was very good. Every sentence was true, and every sentence was pointed the wrong way. And if I had been a different woman, I would have been standing up by then explaining myself, which is the entire purpose of a sentence like that. I opened the box and put 1 page on the table and turned it to face her. Not an accounting, not the report. A photocopy of a piece of lined notebook paper, dated the 9th of November, 1994, in a young woman's round handwriting, which Glenda Whitcomb had attached as an exhibit to her own adoption petition in 1996 in order to prove she had permission. Dear Glenda, I know you think I'm too young, and maybe you're right. I'm going to finish the program in Erie, and then I'm coming back for him. You said I could come at Christmas. I put his gown in the bag, the one with my initials, because I want him to have something that was mine when he's older. Please tell him his mother's name sometimes. Nell. Glenda looked at it for about 4 seconds. Then she looked up at me and said, "That's not relevant to the accounting." Drew picked it up. I watched my husband read a letter from his mother, written 7 weeks before she died, in a room over a flower shop, with the other woman sitting across the table saying it wasn't relevant. He said in a completely reasonable voice, "You told me those initials stood for Nana Florence." Glenda said, "Andrew," he said, "you put her in a drawer and you told me a fake name for her." He set the page down and slid it back to me, very carefully, the way you hand back something that isn't yours. "Twice a year I asked you where I got my hands from." Margot said, "This is exactly what she wanted. Look what she's doing to this family." And my husband said the only sentence in this entire story that I have ever wanted to frame. "Margot, she didn't write the letter, she just found it." We left at 4:10. I sat in the car and typed the whole thing out and sent it to Adele before I turned the key. In the parking lot behind the flower shop, Drew stood with his keys in his hand and asked me what happens now, and I told him the truth. The court would order an interim accounting with bank records attached, and then everyone would find out whether $206,000 was actually in there. He said, "You don't think it is?" I said, "I think a woman who has that much doesn't drive to Vance County to file the same sentence 25 times. The interim accounting was ordered on the 15th of June and due in 20 days, with bank statements attached, which is the part that ends people. You can write any sentence you like on a court form. You cannot write a sentence on a Fidelity Reserve statement. It came in on the 2nd of July. Adele called me at 8:20 in the morning and said, "Are you sitting down?" And I said I was standing in a kitchen with a 14-pound baby on my hip, and she said that would do. $41,500. The trust that had been reported to a court in February as holding $206,000 contained $41,500 and had contained less than 60 since 2021. The rest was in the statements, going back as far as the bank would produce them, and it was not a heist. That's what I wasn't ready for. There was no single terrible day. It was 25 years of a woman moving money from a dead girl's father to her own life in amounts that never looked like anything. A roof, a Buick, a cruise, 4 years of tuition for a daughter who was hers, trustee commissions taken every February like a salary, $94,000 into an insurance agency in 2018, and $112,000 in 2021, $26,000 into a 9-year-old's education account in 2023. Adele's filing put the surcharge figure at $612,000, which is what you get when you add the principal she took to the income the trust should have earned and never did. $612,000. And my husband had spent 3 semesters at community college because a 4-year school wasn't in the cards for us. The collapse after that was not dramatic. It was administrative, which is worse, because administrative things do not stop to hear your side. An insurance agency that has received 2 transfers, totaling $206,000, from a fiduciary account, has a problem with more than one regulator. Adele sent a copy of the interim accounting to the state insurance department because nothing on earth stopped her, and because a fiduciary transfer into a licensed agency is the exact thing that department exists to look at, and the department opened an inquiry into Whitcomb and Doyle on the 10th of July, and the carrier that wrote 60% of the agency's commercial book suspended its appointment the following week, pending the outcome. You cannot sell a policy for a company that has suspended you. Margot laid off 2 producers on a Friday and put the Kingsley lease into default. Adele also filed a complaint with the Disciplinary Board of the Supreme Court of Pennsylvania regarding an attorney who had prepared and countersigned 25 annual accountings stating that a man in his 30s was a minor in the care of the trustee. Rowena Pike consented to a 2-year suspension rather than answer a petition for discipline, and the order came down the following spring. And the notice that goes out lists the client, the county, and the year of each filing, all 25 of them, in a column. And my husband got called by a lawyer he'd never met and asked to produce every commission statement he'd received from the agency since 2018. That was Drew's bill, and I did not shield him from it, and I'm not going to soften it now. He sat at our table for 4 nights with a laptop and a shoebox, printing out records that helped the case against his own mother and his own sister. And on the 5th night he said quietly that Margot had told him he could clear out his desk. 10 years of clients. She kept the book. He is an adjuster now for a regional carrier, salaried, with a badge and a company car, starting over at 32. Hi is not the hero of this. He gets one line in it, and he earned exactly that. He did the right thing 6 weeks after it would have cost him nothing, and by the time he did it, it cost him everything he had. Now here is what Glenda did in July, with all of that going on around her, because she was still, in her own mind, a woman being wronged. On the 22nd of July, she filed a petition for grandparent partial custody of my son. Her position, in writing, sworn, that she had a substantial ongoing relationship with the child, that the child's mother was interfering with it out of spite, that the mother had exhibited instability, litigiousness, and paranoia following the birth, and that a court should order her 3 hours of visitation on alternating Sundays. Adele read it out loud to me over the phone and had to stop twice. Because the thing about a sworn petition is that it goes in the same courthouse as the other file. And her sworn statement that she had been the child's devoted grandmother since birth sat about 9 inches away, in the same building, from her own lab report, excluding her from the family by blood, and from 25 filings in which she swore that same family's beneficiary was a child in her care. She spent 2 weeks calling everyone she knew to tell them I was keeping her grandson from her. She had a prayer chain going. A woman I barely know stopped me outside the Acme and told me she'd be praying for softening, and I said thank you and put my groceries in the car. The petition was dismissed on the 18th of August without a hearing, on the pleadings, because in Pennsylvania, a grandparent has standing in narrow circumstances, and none of them is a marriage that is still intact under one roof. It cost her $2,200 in fees, and it put a document in the record that Adele attached to our own filing as Exhibit F. There was one thing I would not do, and I did it in Adele's office on the 11th of August, and it is the only decision in this whole story I made without writing anything down first. She had the recovery plan on the desk. She'd traced every dollar we could realistically reach, and one of the lines was $26,000 sitting in a 529 college savings account for EMD, which had grown to a little over $31,000, and which was recoverable as a fraudulent transfer because a 9-year-old cannot be a good faith purchaser of anything. I said, "Take it off." Adele said, "It's clean money to claw back, she has no defense." I said, "She's 9, she's not in the box." Adele looked at me for a second, and then she drew a line through it with a pen and said, "Then it's off." And we moved on to the next page, and I didn't think about it again for 4 months. The hearing on the petition to surcharge and remove the trustee was set for the 21st of September at 9:30 in the morning in Courtroom 2 in Vance County before Judge Marla Ostrander, open to the public. I called the parish office and asked for one thing: the name and mailing address of every person who had signed the guest book at my son's baptism. 41 names. The secretary gave them to me without asking why, and I think she knew why. Adele subpoenaed 4 of them as witnesses to the events of the 8th of March. The other 37 just came. There were 6 weeks between that and the hearing, and 3 things happened in them, and the first one had nothing to do with money. Nell Ferris had a first cousin. Her name is Doreen. She is 58. She lives 11 miles from the machine shop that used to be Harlan's and is now a place that sells above-ground pools, and I found her the way anybody finds anybody. The obituary listed survivors, and one of the survivors had a daughter, and the daughter is on the internet. I called on a Sunday afternoon in August. I said my name, and that I was married to a man born in September of 1994, and I got about that far. She said, "Say that again." I said it again. Doreen Ferris put the phone down on a hard surface, and I could hear her walking away from it, and I could hear a screen door, and she was gone for maybe 40 seconds. And when she came back, her voice was wrecked. "We were told he was adopted out of state," she said, "by a couple in Ohio. Glenda Whitcomb sat in my aunt's kitchen in February of '95 and told us the agency wouldn't release the name, and that it was closed, and that we should let him have a clean start. I said, "He lived 190 miles from you, in this state, under the name Whitcomb." She said, "I know what he lived from. I'm asking you to tell me what he lived like." They met on the last Saturday in August, at a diner off Route 6, because Doreen said she didn't want the first time to be in anybody's house where somebody could leave. She brought a shoebox. Nell at 7 on a pony at a fair. Nell at 16 in a marching band uniform holding a clarinet like it was heavy. Nell at 22, 8 months along, standing in front of a screen door in July heat in a red sundress with both hands on top of her stomach and her chin up, absolutely daring the camera. Drew looked at that one for a long time and then he said, "That's Owen's hairline." Doran said, "That's your hairline." She told him his grandfather kept a bank passbook in a coffee can and used to say he was building something for the boy, and that after he died in 2001, they assumed the money had gone with the adoption to Ohio. She told him Nell had been 3 weeks from finishing her clinicals. She told him the gown had been made by Harlan's wife, who was already sick when she made it, and that the initials were stitched in ivory because Nell wanted something that wouldn't show a stain, and that she had sewn it for a baptism she never got to sit in the front row of. She did not say one word about a lawsuit. At the end, she asked if she could hold the baby, and then she asked if she could hold him again. "That is the part I would like you to keep, if you keep any of it." 6 weeks before a courtroom, in a diner with laminated menus, a woman who had been robbed of 31 years of a nephew did not say a single ugly thing about the person who took them. She just kept saying his name to get used to it. The second thing was a house. In the 2009 accounting, there is a disbursement of $140,000 described as investment, real property. I had read that line 11 times before I thought to ask what property. Vance County has its deeds online. It took 9 minutes. A 3-bedroom cottage on Kell Pond, purchased in June of 2009, cash, titled in the name of Glenda M. Whitcomb, individually. That cottage is where the Whitcombs go the first 2 weeks of July. There is a picture of Drew on the dock at 15 holding a base. Margot got married on the lawn. Etta learned to swim off the ladder on the left side, and there is a door frame inside the kitchen with pencil marks on it, and dates going back to 2010. And one of those marks is a 9-year-old's, from June. And one of them, from 4 years ago, says Drew's hand flat on head as a joke, in his mother's handwriting. A trustee cannot buy herself a lake house with the beneficiary's money. There is no version of that. There is no explanation involving a misunderstanding at a collection site. She listed it on the 2nd of September for $265,000 with a broker in Kingsley and told him she needed a quick close. Adele filed for an injunction and a lis pendens on the 4th. The court entered it on the 9th. A lis pendens is a piece of paper that goes on the deed and says, to anyone thinking about buying, that this property is the subject of litigation. It does not stop a sale legally. It stops it practically, in about the time it takes a title company to read. Her buyer walked on the 11th, and the third thing was the letter. On the 14th of September, 1 week before the hearing, Glenda Whitcomb mailed a 2-page letter to 39 households in our parish. I know it was 39 because 11 of them mailed it to me. It was, I have to admit, well written. It said that she had been advised not to speak and that she could no longer stay silent while her family was destroyed. It said that she had taken in an infant when no one else would and had never once treated him as anything but her own son. It said that a young woman with no family of her own had come into their lives and had systematically isolated her son, weaponized a private medical test, manipulated a priest, and was now using an infant as a plaintiff to extract money from a widow. It asked for prayers. It gave the date, time, and courtroom number of the hearing, and said that anyone who wished to see the truth for themselves was welcome to attend. She invited them. She stood there and stamped 39 envelopes, and she invited the whole parish to watch, because she believed, all the way to the end, that a room full of people who knew her was a room that belonged to her. I read it twice at my kitchen table, and then I scanned it and sent it to Adele with a 2-word note. Exhibit J. Adele wrote back, "She's really going to do our closing for us, isn't she?" And I sat there with my hand flat on the table for a minute, And I'd like to tell you I felt something clean and sharp. What I actually felt was tired, and underneath the tired was one small hot thing I am not proud of, and the small hot thing was this. For 4 years that woman had made me the person who could not be believed, and in 7 days a stranger in a black robe was going to read every word she had written down herself, out loud, into a record that no one in that family would ever be able to edit. The night before, Drew came into the nursery at 11 and stood in the doorway. He said, "If I sit on your side, that's it. That's the last day I have a mother." I said, "Sit wherever you want. I'm not going to trade you anything for it." He said, "That's not an answer." I said, "It's the only one I've got that's true." And I put Owen down, and I went to bed, and I slept about 2 hours, and at 4 in the morning I got up and ironed a gray suit and typed the exhibit list one more time, even though it had been final for 9 days, because the only thing that has ever helped me is putting things in order. At 9:04 the next morning, in the hallway outside courtroom 2, a lawyer I had never seen before, Glenda had hired someone out of Erie, asked Adele for 2 minutes. How was pleasant about it? He said his client was prepared to consent to removal, to a full surcharge of $612,000 secured by the Kell Pond property and her residence, and to a payment schedule, effective immediately, before any testimony. Everything we had asked for, every dollar, on one condition. The petition would be marked settled, the exhibits withdrawn, and the record sealed. Adele stepped over to me by the window at the end of the hall, where the radiator is, and told me. She said it was more than we would likely collect after a trial. She said, and she was right, that a judgment is a piece of paper and a consent secured by real estate is money. She said, "Paige, this is the win. I have to tell you that it's the win." Down the hall. Glenda was sitting on a bench in navy with her purse on her knees, and she looked at me, and she did the smallest thing. She lifted her chin about half an inch. She thought she was buying my silence with the money she took from a dead girl's father, and she thought I would take it, because in her version of me, I am a woman who counts pages at $11 apiece. I said no. Adele said, "Tell me why so I can put it in my file." I said, "Because in 10 years my son is going to ask what happened, and I'm not going to hand him a sealed envelope." We went in at 9:30. The gallery holds about 60 people. It was full by 20 past, and it was full of the parish, because she had mailed them the courtroom number herself. Father Brennan sat in the third row. Doreen Ferris sat in the second with a shoebox on her lap that she never opened. Drew sat behind me, on the left, which is the petitioner's side, and Margot sat on the right and did not look at him once. I had my son with me for the first 11 minutes, and then Doreen took him out to the hallway, because a courtroom is no place for a baby, and because I did not want him in the room for what came next. Judge Marla Ostrander is unhurried, she reads. Adele's case took 90 minutes, and it had no speeches in it. She put in the will, and the clause about a grandchild, and 25 accountings, and had a paralegal read one sentence from each of them in order, by year, out loud. 25 times. The beneficiary remains a minor in the care and custody of the trustee. 2013, 2016, 2019, 2022, 2024. The gallery started out patient. By about the 19th year, the sound in that room had changed completely, and by the last one, nobody was moving at all, and that was done with no argument whatsoever, just a woman in her 20s reading the same line 25 times in a flat voice. Then the bank statements, then the deed to Kell Pond, then the invoice from a laboratory in Cleveland, and the check image. Judge Ostrander held that one up herself and read it into the record, and she read all of it, the way she reads everything. Case number 31902. Amount, $490. Payer of record, the Ferris Family Trust. Signature line, G. Whitcomb, trustee. Then she set it down and looked over the top of the page at the gallery, at a room of people who had spent 6 months being told this was a misunderstanding about a baby, and she said, "So the trust paid for it." Then the video. They played 4 minutes of it on a monitor turned toward the bench. The picture is a tablecloth, a candle, and somebody's elbow, because that camera never came up off Kayla's hip. The sound is perfect, because a parish hall has hard walls. The courtroom heard a woman's church voice say that she had ordered it in January and paid for it herself, and that everyone deserved to know whose he was. And then, in a room with a judge in it, 60 people heard the sound of a pacifier being set down on a tablecloth, and a woman saying, "I already had his, I took it in February, it only needs the spit." I watched the third row instead of the screen. I watched what happened to their faces, and I understood that until that moment, most of them had genuinely believed there had been a misunderstanding at a christening, and that the whole thing had been ugly on both sides. Adele's last exhibit was a spiral notebook. I have written verbatim in steno since I was 22. On the night of the 8th of March, after Owen went down, I sat on the nursery floor and wrote out that lunch from memory in shorthand, dated, timed, and initialed at the bottom of the page, because that is what you do with a contemporaneous record. The judge asked me to authenticate it. Then she said, "Madam Court Reporter, would you read Exhibit K into the record?" And the woman at the machine below the bench read my notes out loud, in a courtroom, into a transcript, and every word I had written on my own floor at 11 o'clock at night with a baby monitor hissing on the carpet became part of the permanent record of the Court of Common Pleas of Vance County, Orphans Court Division. I was 14 years old the first time I understood that some people's words go in the book and some people's don't. I sat there with my hands flat on the table and let somebody read mine. They put her on the stand at 11:40. Her lawyer was careful with her. He walked her through 1994 and the hospital hallway and the promise, and she was good. She was better than good, and for about 6 minutes the room went with her, because it is a genuinely terrible story, and she had genuinely lived it. Then Adele stood up and asked her 4 questions. "Mrs. Whitcomb, in what year did the beneficiary of this trust turn 18? She said 2012. "And in February of 2013, and every February after that, you filed a document with this court stating he remained a minor in your care. Is that your signature?" She said it was a form. She said Rowena prepared them, and she signed what was put in front of her. In 2009, the trust disbursed $140,000 for investment in real property, whose name is on the deed. There was a long pause. She said mine, but it was for the family. Last question. On the 8th of March of this year, when you paid a laboratory in Cleveland $490 from this trust to test the beneficiary's infant son, had you told the beneficiary that this trust existed? And Glenda Whitcomb said, into a microphone, in front of a gallery she had invited herself, "He didn't need to know, he would have spent it." That was it. That was the whole thing. And she said it herself, and she said it in the tone of a woman explaining something obvious to people who were being slow. Judge Ostrander removed her as trustee from the bench at 12:15, appointed a corporate successor, and took the surcharge under advisement pending a written opinion. Nobody clapped. That's not what happens. 60 people picked up their coats and filed out of a courtroom very quietly, and in the hallway Father Brennan put his hand on my arm for about a second and didn't say anything, and Doreen handed me my son, who had slept through all of it, and Margot went down the stairs instead of waiting for the elevator with the rest of us. Drew stood in the parking lot and cried with his hands over his face, standing up, for a long time, and I let him, and I did not tell him it was going to be all right, because it wasn't, and he knew it wasn't, and he had earned the right to not be lied to. 12 days later, my sister-in-law's daughter knocked on my door. They came together, which I hadn't expected. Margot stood on the walk with her arms crossed and her jaw set like a woman who has been dragged somewhere. Etta came up the steps by herself with a folded piece of paper in both hands. "Etta is 9. She has a gap in her front teeth and she can name every bone in the hand." She said, "Is Owen awake?" I said he was, and I brought him to the door, and she looked at him for a while, and then she held out the paper. It was a printout of an account statement. $31,200 in a 529 plan, custodian Marguerite Whitcomb Doyle, beneficiary Etta Marie Doyle. I said, "Honey, that's yours, nobody's touching that. I told my lawyer to leave it alone in August." She said, "I know, my mom told me you did that." She pushed it at me another inch. "But it isn't mine." I said, "Etta," and she said, "It came from Owen's other grandma's dad." She had clearly practiced it, and she got the words in the right order, and her chin was going. "It was for a baby. Grandma took it and gave it to me for college, and I didn't know, but I know now, so I can't have it." I looked over her head at her mother. Margot said, in a voice like gravel, She found the letter about it in my desk. She has asked me every day for 9 days. She looked away down the street. I signed the transfer this morning. Don't say anything to me about it. Just take the paper. There is a version of this where I stood on my own porch and felt something like victory. I want to be honest with you. What happened was that a 9-year-old handed her whole college fund to a baby who wasn't 9 months old because she had done the arithmetic on right and wrong faster than 3 adults in her family had managed in 31 years. And I sat down on the step in my own doorway with a baby on my arm and could not get my throat to work. I said, "You could have kept it. Nobody would have known." And Etta said, "I would have known. It's on paper." Judge Ostrander's written opinion came down on the 6th of October, 22 pages. She surcharged Glenda M. Whitcomb $612,000, entered it as a judgment, and attached it as a lien to the residence on Barrow Street and to the cottage on Kell Pond. She ordered the successor trustee to liquidate both and to render a final accounting to the beneficiary. She denied the request for trustee commissions for every year since 2012 and ordered those repaid separately. And on page 19, in one sentence with no adjectives in it, she referred the file to the District Attorney of Vance County for review of theft by failure to make required disposition of funds received. The last line of the opinion is the only one anybody in that family remembers. The court notes that the trustee's fiduciary duty ran to a person whose existence she had spent 31 years arranging to be the only fact he did not know about himself. The successor trustee scheduled the cottage clear-out for the first Saturday in November. Family gets 1 day to remove personal property before a company comes and boxes the rest. I wasn't going to go. Drew had to, his boat things, a footlocker of his father's. And he asked me at 7 in the morning, standing in the kitchen with his coat already on, if I'd come, and I said yes, because Owen had never seen the water, and because I have never once in my life been able to stay away from the end of a record. It was cold. Kell Pond in November is gray on gray, with a line of yellow in the trees on the far side. Glenda was there in a barn coat, directing, which is what she does. She had 4 boxes and a laundry basket and a look on her face like a woman supervising a renovation. She did not speak to me. She spoke around me all morning to Drew cheerfully about which lamp had been her mother's, and every time she said it, Drew said, "Okay, Mom," and put it in the truck. Margot came at 11 with Etta. Etta went straight past the adults and into the kitchen, and she stood in front of the door frame with the pencil marks on it, and she put her finger on the one from June, and then on the one 4 years above it in her grandmother's handwriting, and then she came out onto the porch where I was standing with the baby. She was carrying something folded in tissue paper, the christening gown. Ivory, with NF, stitched into the hem in thread that has gone the color of tea. "It was in the cedar chest," she said. "It's his. It's from his real grandma." Glenda heard that from the yard. She came up 2 steps and said sharply, "Etta, that is a Whitcomb heirloom and it goes with me." And her granddaughter turned around on the top step, with a 140-year-old lake behind her and said, "It has her letters on it, Grandma, not ours." Nobody said anything for a second. Then Etta went down the steps past her and out to her mother's car, and at the bottom she stopped and turned around one more time, and she was not angry. That's the thing. There was nothing in her face except a child being careful. She said, "Goodbye, Mrs. Whitcomb. I have watched a great many people be destroyed in rooms with recording equipment in them. I have taken down the exact words of men being told they will lose their companies. I have never seen anything take a person apart like a 9-year-old changing what she calls you and then getting in a car." Glenda stood in that yard with a laundry basket in her arms and her mouth slightly open and looked at me for the first time all day. Not with hate. With something worse for her, which was that she finally wanted me to say something, anything, so there would be a conversation for her to be in. I said one sentence, and it was the only sentence I said to her that entire day, and it is the last thing I have ever said to her. "You told everyone the truth was worth doing on a Sunday." Then I went and put my son in the car. The gown was in his lap the whole way home, in its tissue paper, on top of the diaper bag, and Drew drove and didn't say anything for about 40 miles, and then, somewhere on Route 6 past the place where the machine shop used to be, he said, "She kept it. For 31 years she kept it in a chest, and every time she opened that lid she saw those letters." I said, "I know." He said, "What do you do with that?" And I said the truest thing I had. "You tell him her name, starting now, sometimes." That was 18 months ago. Here is where everybody landed. The house on Barrow Street sold in March for $209,000, and every cent of it went to the judgment. The cottage on Kell Pond went in April to a family from Bethlehem with 3 kids and a dog, and the successor trustee's final accounting recovered $461,000 of the $612. The rest is a payment order against a woman on a fixed income at $300 a month, which will outlive her and which she has never once missed, because being seen to pay is the last respectable thing she has. The district attorney of Vance County charged her in February. She pled guilty in June to theft by failure to make required disposition of funds received. She is 66 and had never had so much as a parking ticket, so she got 2 years probation and a restitution order, and the local paper ran 11 inches on it with her age in the first line. She transferred to a parish 2 towns over. I'm told she is on the altar guild there, and that she is very well thought of, and I hope that's true, and I mean that in a way that is not generous. I hope she has 40 people to be respected by, and I hope not one of them ever learns her son's mother's name. Rowena Pike was suspended for 2 years. The disciplinary notice lists every filing by year, in a column, 25 lines long, and it is a public document, and it will be findable by anyone with her name for the rest of time. She sold the office over the flower shop and moved in with her sister in Delaware. Whitcomb and Doyle is now just Doyle, in a smaller space on 3rd, without the commercial appointment that was 60% of the book. Margot works Saturdays. She and I are polite. We are never going to be anything else, and we both stopped auditioning for it about a year ago, and I have come to think that is a kind of peace. Doreen Ferris comes down the first Sunday of every month with the shoebox, which is not a shoebox anymore because Drew bought her an album for Christmas and sat with her at our table for 4 hours while she wrote on the back of every photograph in pencil. Who, where, what year. Nell's picture in the red sundress is on our stairs, second from the bottom, at the height where a child on his way up will be looking. Owen turned 2 in January. He runs like something is chasing him, and he puts 3 words together now, and one of them is always duck. The gown came out once, on the 8th of March last year, at a mass Father Brennan said for the anniversary, laid across my arm with Owen asleep against it, and it went back in its tissue paper afterward, and it will go to him when he is old enough to be told the whole thing, which he will be, because I am not raising a man whose family history is a document he has to request from the state at 31. Drew slept in the small room off the landing for 5 months. We did 9 months of counseling, and we are not what we were, and anyone who tells you a marriage snaps back after something like this is selling something. What we are is 2 people who built a different thing on top of the wreck of the first one, on purpose, slowly, with him doing most of the carrying, because he was the one who spent 6 weeks choosing wrong. He is an adjuster now. He drives a company car, and he is home by 6 every night, which he never was, and last month he took Owen to Kell Pond and stood on the public boat ramp and pointed at somebody else's dock. And Etta. $31,200 went out of a 9-year-old's account and into an 8-month-old's in October because she wouldn't take no. In May, when the recovery came through, Drew opened a new 529 in her name and put $50,000 into it out of his own share, which was his to give and not mine, and I want to be exact about that because it matters that it was his. Adele drew up a letter to go with it, on real letterhead, addressed to Etta Marie Doyle, explaining in plain language where the money came from, why it was legally and morally hers, and who had decided that. Margot called me the night it arrived. First time in 7 months. She said Etta had read it 4 times and then asked if she could keep the letter in the box with it. Not the money, the letter. She's 11 now. She wants to be an orthopedic surgeon, hands specifically, and she can still name every bone in one, and she told me at Easter that she's going to fix people's hands so they can keep working. And I said that sounded like a good life, and she said, it's 12 years of school, like a woman reading a docket. I think about that kid more than I think about her grandmother. Here's the thing I did not expect, and then I'll let you go. I don't have a moment of triumph in my head from any of this. The courtroom isn't it. The judgment isn't it. What I have is a Tuesday in April, ordinary, nothing happening, when the parish office called about a certificate for the preschool registration, and I drove over, and the secretary went into the safe and brought out the register, this enormous bound book, and turned it around on the counter so I could check the spelling myself. There he was, line 11, his whole name in fountain pen, dated the 8th of March. I stood in a church office and looked at my son's name in a book for probably a minute and a half, and the secretary let me and did not ask why. If you have someone in your life who has decided what you are and has been quietly telling everyone else that version for years, I know how it feels to want to stand up and correct them in front of the room. Don't. Write it down instead. Dates, words, exactly what was said. Not because you're going to sue anybody. Because the version people believe is the version that's written somewhere, and right now the only one that exists is theirs. So tell me, have you ever had a family member decide who you were before they knew you, and did you ever get it corrected? Or is that story still sitting in you with nowhere to go? Put it below. I read them, all of them, and I read the long ones twice. And if this one got you, stay with me for the next one. Thank you for sitting with me all the way to the end of it. I know it was long, so was the wait.